This is a Strategic Scholars recording. Visit audiolawlibrary.com to listen to other famous, notorious, or intriguing Supreme Court opinions, laws, and other writings from United States history. This is a reading of Texas v. Johnson, a United States Supreme Court opinion decided on June 21, 1989. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Justice William Brennan delivered the opinion of the court. After publicly burning an American flag as a means of political protest, Gregory Lee Johnson was convicted of desecrating a flag in violation of Texas law. This case presents the question whether his conviction is consistent with the First Amendment. We hold that it is not. Section 1. While the Republican National Convention was taking place in Dallas in 1984, Respondent Johnson participated in a political demonstration dubbed the Republican War Chest Tour. As explained in literature distributed by the demonstrators and in speeches made by them, the purpose of this event was to protest the policies of the Reagan administration and of certain Dallas-based corporations. The demonstrators marched through the Dallas streets, chanting political slogans and stopping at several corporate locations to stage die-ins intended to dramatize the consequences of nuclear war. On several occasions, they spray-painted the walls of buildings and overturned potted plants, but Johnson himself took no part in such activities. He did, however, accept an American flag handed to him by a fellow protester who had taken it from a flagpole outside of one of the targeted buildings. The demonstration ended in front of Dallas City Hall, where Johnson unfurled the American flag, doused it with kerosene, and set it on fire. While the flag burned, the protesters chanted, "America, the red, white, and blue, we spit on you." After the demonstrators dispersed, a witness to the flag burning collected the flag's remains and buried them in his backyard. No one was physically injured or threatened with injury, though several witnesses testified that they had been seriously offended by the flag burning. Of the approximately 100 demonstrators, Johnson alone was charged with a crime. The only criminal offense with which he was charged was the desecration of a venerated object in violation of Texas Penal Code annotated section 42.09. After a trial, he was convicted, sentenced to 1 year in prison, and fined $2,000. The Court of Appeals for the 5th District of Texas at Dallas affirmed Johnson's conviction, but the Texas Court of Criminal Appeals reversed, holding that the state could not, consistent with the First Amendment, punish Johnson for burning the flag in these circumstances. The Court of Criminal Appeals began by recognizing that Johnson's conduct was symbolic speech protected by the First Amendment. Given the context of an organized demonstration, speeches, slogans, and the distribution of literature, anyone who observed appellant's act would have understood the message that appellant intended to convey. The act for which appellant was convicted was clearly speech, contemplated by the First Amendment. To justify Johnson's conviction for engaging in symbolic speech, the state asserted two interests: preserving the flag as a symbol of national unity and preventing breaches of the peace. The Court of Criminal Appeals held that neither interest supported his conviction. Acknowledging that this court had not yet decided whether the government may criminally sanction flag desecration in order to preserve the flag's symbolic value, the Texas court nevertheless concluded that our decision in West Virginia Board of Education versus Barnett suggested that furthering this interest by curtailing speech was impermissible. Recognizing that the right to differ is the centerpiece of our First Amendment freedoms, the court explained. A government cannot mandate by fiat a feeling of unity in its citizens. Therefore, that very same government cannot carve out a symbol of unity and prescribe a set of approved messages to be associated with that symbol when it cannot mandate the status or feeling the symbol purports to represent. Noting that the state had not shown that the flag was in grave and immediate danger of being stripped of its symbolic value, the Texas court also decided that the flag's special status was not endangered by Johnson's conduct. As to the state's goal of preventing breaches of the peace, the court concluded that the flag desecration statute was not drawn narrowly enough to encompass only those flag burnings that were likely to result in a serious disturbance of the peace. And in fact, the court emphasized, the flag burning in this particular case did not threaten such a reaction. Serious offense occurred, the court admitted, but there was no breach of peace, nor does the record reflect that the situation was potentially explosive. One cannot equate serious offense with incitement to breach the peace. The court also stressed that another Texas statute, Texas Penal Code annotated section 42.01, prohibited breaches of the peace. Citing Booz v. Berry, the court decided that section 42.01 demonstrated Texas's ability to prevent disturbances of the peace without punishing this flag desecration. Because it reversed Johnson's conviction on the ground that section 42.09 was unconstitutional as applied to him, the state court did not address Johnson's argument that the statute was, on its face, unconstitutionally vague and overbroad. We granted certiorari and now affirm. Section 2. Johnson was convicted of flag desecration for burning the flag, rather than for uttering insulting words. This fact somewhat complicates our consideration of his conviction under the First Amendment. We must first determine whether Johnson's burning of the flag constituted expressive conduct, permitting him to invoke the First Amendment in challenging his conviction. If his conduct was expressive, we next decide whether the state's regulation is related to the suppression of free expression. If the state's regulation is not related to expression, then the less stringent standard we announced in United States v. O'Brien for regulations of non-communicative conduct controls. If it is, then we are outside of O'Brien's test, and we must ask whether this interest justifies Johnson's conviction under a more demanding standard. A third possibility is that the state's asserted interest is simply not implicated on these facts, and, in that event, the interest drops out of the picture. The First Amendment literally forbids the abridgment only of speech, but we have long recognized that its protection does not end at the spoken or written word. While we have rejected the view that an apparently limitless variety of conduct can be labeled speech whenever the person engaging in the conduct intends thereby to express an idea, we have acknowledged that conduct may be sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. In deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, we have asked whether an intent to convey a particularized message was present, and whether the likelihood was great that the message would be understood by those who viewed it. Hence, we have recognized the expressive nature of students' wearing of black armbands to protest American military involvement in Vietnam, of a sit-in by blacks in a whites-only area to protest segregation, of the wearing of American military uniforms in a dramatic presentation criticizing American involvement in Vietnam, and of picketing about a wide variety of causes. Especially pertinent to this case are our decisions recognizing the communicative nature of conduct relating to flags, attaching a peace sign to the flag, refusing to salute the flag, and displaying a red flag, we have held, all may find shelter under the First Amendment. That we have had little difficulty identifying an expressive element in conduct relating to flags should not be surprising. The very purpose of a national flag is to serve as a symbol of our country. It is, one might say, the one visible manifestation of 200 years of nationhood. The flag salute is a form of utterance. Symbolism is a primitive but effective way of communicating ideas. The use of an emblem or flag to symbolize some system, idea, institution, or personality is a shortcut from mind to mind. Causes and nations, political parties, lodges, and ecclesiastical groups seek to knit the loyalty of their followings to a flag or banner, a color or design. Pregnant with expressive content, the flag as readily signifies this nation as does the combination of letters found in America. We have not automatically concluded, however, that any action taken with respect to our flag is expressive. Instead, in characterizing such action for First Amendment purposes, we have considered the context in which it occurred. In Spence, for example, we emphasize that Spence's taping of a peace sign to his flag was roughly simultaneous with and conceitedly triggered by the Cambodian incursion and the Kent State tragedy. The state of Washington had conceded, in fact, that Spence's conduct was a form of communication, and we stated that the state's concession is inevitable on this record. The state of Texas conceded for purposes of its oral argument in this case that Johnson's conduct was expressive conduct, and this concession seems to us as prudent as was Washington's in Spence. Johnson burned an American flag as part, indeed as the culmination, of a political demonstration that coincided with the convening of the Republican Party and its renomination of Ronald Reagan for president. The expressive, overtly political nature of this conduct was both intentional and overwhelmingly apparent. At his trial, Johnson explained his reasons for burning the flag as follows. The American flag was burned as Ronald Reagan was being renominated as president, and a more powerful statement of symbolic speech, whether you agree with it or not, couldn't have been made at that time. It's quite a juxtaposition. We had new patriotism and no patriotism. In these circumstances, Johnson's burning of the flag was conduct sufficiently imbued with elements of communication to implicate the First Amendment. Section 3. The government generally has a freer hand in restricting expressive conduct than it has in restricting the written or spoken word. It may not, however, prescribe particular conduct because it has expressive elements. What might be termed the more generalized guarantee of freedom of expression makes the communicative nature of conduct an inadequate basis for singling out that conduct for prescription. A law directed at the communicative nature of conduct must, like a law directed at speech itself, be justified by the substantial showing of need that the First Amendment requires. It is, in short, not simply the verbal or nonverbal nature of the expression, but the governmental interest at stake that helps to determine whether a restriction on that expression is valid. Thus, although we have recognized that, where speech and non-speech elements are combined in the same course of conduct, a sufficiently important governmental interest in regulating the non-speech element can justify incidental limitations on First Amendment freedoms. We have limited the applicability of O'Brien's relatively lenient standard to those cases in which the governmental interest is unrelated to the suppression of free expression. In stating, moreover, that O'Brien's test in the last analysis is little, if any, different from the standard applied to time, place, or manner restrictions, we have highlighted the requirement that the governmental interest in question be unconnected to expression in order to come under O'Brien's less demanding rule. In order to decide whether O'Brien's test applies here, therefore, we must decide whether Texas has asserted an interest in support of Johnson's conviction that is unrelated to the suppression of expression. If we find that an interest asserted by the state is simply not implicated on the facts before us, we need not ask whether O'Brien's test applies. The state offers two separate interests to justify this conviction: preventing breaches of the peace and preserving the flag as a symbol of nationhood and national unity. We hold that the first interest is not implicated on this record, and that the second is related to the suppression of expression. Subsection A. Texas claims that its interest in preventing breaches of the peace justifies Johnson's conviction for flag desecration. However, no disturbance of the peace actually occurred or threatened to occur because of Johnson's burning of the flag. Although the state stresses the disruptive behavior of the protesters during their march toward City Hall, it admits that no actual breach of the peace occurred at the time of the flag burning or in response to the flag burning. The state's emphasis on the protesters' disorderly actions prior to arriving at City Hall is not only somewhat surprising, given that no charges were brought on the basis of this conduct, but it also fails to show that a disturbance of the peace was a likely reaction to Johnson's conduct. The only evidence offered by the state at trial to show the reaction to Johnson's actions was the testimony of several persons who had been seriously offended by the flag burning. The state's position, therefore, amounts to a claim that an audience that takes serious offense at particular expression is necessarily likely to disturb the peace, and that the expression may be prohibited on this basis. Our precedents do not countenance such a presumption. On the contrary, they recognize that a principal function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. It would be odd indeed to conclude both that if it is the speaker's opinion that gives offense, that consequence is a reason for according it constitutional protection, and that the government may ban the expression of certain disagreeable ideas on the unsupported presumption that their very disagreeableness will provoke violence. Thus, we have not permitted the government to assume that every expression of a provocative idea will incite a riot, but have instead required careful consideration of the actual circumstances surrounding such expression, asking whether the expression is directed to inciting or producing imminent lawless action, and is likely to incite or produce such action. To accept Texas's arguments that it need only demonstrate the potential for a breach of the peace, and that every flag burning necessarily possesses that potential, would be to eviscerate our holding in Brandenburg. This we decline to do. Nor does Johnson's expressive conduct fall within that small class of fighting words that are likely to provoke the average person to retaliation, and thereby cause a breach of the peace. No reasonable onlooker would have regarded Johnson's generalized expression of dissatisfaction with the policies of the federal government as a direct personal insult or an invitation to exchange fisticuffs. We thus conclude that the state's interest in maintaining order is not implicated on these facts. The state need not worry that our holding will disable it from preserving the peace. We do not suggest that the First Amendment forbids a state to prevent imminent lawless action, and, in fact, Texas already has a statute specifically prohibiting breaches of the peace, which tends to confirm that Texas need not punish this flag desecration in order to keep the peace. Subsection B. The state also asserts an interest in preserving the flag as a symbol of nationhood and national unity. In Spence, we acknowledge that the government's interest in preserving the flag's special symbolic value is directly related to expression in the context of activity, such as affixing a peace symbol to a flag. We are equally persuaded that this interest is related to expression in the case of Johnson's burning the flag. The state, apparently, is concerned that such conduct will lead people to believe either that the flag does not stand for nationhood and national unity, but instead reflects other, less positive concepts, or that the concepts reflected in the flag do not in fact exist, that is, that we do not enjoy unity as a nation. These concerns blossom only when a person's treatment of the flag communicates some message, and thus are related to the suppression of free expression, within the meaning of O'Brien. We are thus outside of O'Brien's test altogether. Section 4. It remains to consider whether the state's interest in preserving the flag as a symbol of nationhood and national unity justifies Johnson's conviction. As in Spence, we are confronted with a case of prosecution for the expression of an idea through activity, and accordingly, we must examine with particular care the interests advanced by petitioner to support its prosecution. Johnson was not, we add, prosecuted for the expression of just any idea. He was prosecuted for his expression of dissatisfaction with the policies of this country, expression situated at the core of our First Amendment values. Moreover, Johnson was prosecuted because he knew that his politically charged expression would cause serious offense. If he had burned the flag as a means of disposing of it because it was dirty or torn, he would not have been convicted of flag desecration under this Texas law. Federal law designates burning as the preferred means of disposing of a flag, when it is in such a condition that it is no longer a fitting emblem for display, and Texas has no quarrel with this means of disposal. The Texas law is thus not aimed at protecting the physical integrity of the flag in all circumstances, but is designed instead to protect it only against impairments that would cause serious offense to others. Texas concedes as much. Section 42.09b reaches only those severe acts of physical abuse of the flag carried out in a way likely to be offensive. The statute mandates intentional or knowing abuse, that is, the kind of mistreatment that is not innocent, but rather is intentionally designed to seriously offend other individuals. Whether Johnson's treatment of the flag violated Texas law thus depended on the likely communicative impact of his expressive conduct. Our decision in Booz v. Berry tells us that this restriction on Johnson's expression is content-based. In Booz, we consider the constitutionality of a law prohibiting the display of any sign within 500 feet of a foreign embassy if that sign tends to bring that foreign government into public odium or public disrepute. Rejecting the argument that the law was content neutral because it was justified by our international law obligation to shield diplomats from speech that offends their dignity, we held that the emotive impact of speech on its audience is not a secondary effect, unrelated to the content of the expression itself. According to the principles announced in Booz, Johnson's political expression was restricted because of the content of the message he conveyed. We must therefore subject the state's asserted interest in preserving the special symbolic character of the flag to the most exacting scrutiny. Texas argues that its interest in preserving the flag as a symbol of nationhood and national unity survives this close analysis. Quoting extensively from the writings of this court, chronicling the flag's historic and symbolic role in our society, the state emphasizes the special place reserved for the flag in our nation. The state's argument is not that it has an interest simply in maintaining the flag as a symbol of something, no matter what it symbolizes. Indeed, if that were the state's position, it would be difficult to see how that interest is endangered by highly symbolic conduct such as Johnson's. Rather, the state's claim is that it has an interest in preserving the flag as a symbol of nationhood and national unity, a symbol with a determinate range of meanings. According to Texas, if one physically treats the flag in a way that would tend to cast doubt on either the idea that nationhood and national unity are the flag's reference, or that national unity actually exists, the message conveyed thereby is a harmful one, and therefore may be prohibited. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. We have not recognized an exception to this principle even where our flag has been involved. In Street v. New York, we held that a state may not criminally punish a person for uttering words critical of the flag. Rejecting the argument that the conviction could be sustained on the ground that Street had failed to show the respect for our national symbol which may properly be demanded of every citizen, we concluded that the constitutionality guaranteed freedom to be intellectually diverse or even contrary, and the right to differ as to things that touch the heart of the existing order, encompass the freedom to express publicly one's opinions about our flag, including those opinions which are defiant or contemptuous. Nor may the government, we have held, compel conduct that would evince respect for the flag. To sustain the compulsory flag salute, we are required to say that a Bill of Rights which guards the individual's right to speak his own mind left it open to public authorities to compel him to utter what is not in his mind. In holding in Barnett that the Constitution did not leave this course open to the government, Justice Jackson described one of our society's defining principles in words deserving of their frequent repetition. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. In Spence, we held that the same interest asserted by Texas here was insufficient to support a criminal conviction under a flag misuse statute for the taping of a peace sign to an American flag. Given the protected character of Spence's expression, and in light of the fact that no interest the state may have in preserving the physical integrity of a privately owned flag was significantly impaired on these facts, we held the conviction must be invalidated. In short, nothing in our precedents suggests that a state may foster its own view of the flag by prohibiting expressive conduct relating to it. To bring its argument outside our precedents, Texas attempts to convince us that, even if its interest in preserving the flag's symbolic role does not allow it to prohibit words or some expressive conduct critical of the flag, it does permit it to forbid the outright destruction of the flag. The state's argument cannot depend here on the distinction between written or spoken words and nonverbal conduct. That distinction, we have shown, is of no moment where the nonverbal conduct is expressive, as it is here, and where the regulation of that conduct is related to expression, as it is here. In addition, both Barnett and Spence involved expressive conduct, not only verbal communication, and both found that conduct protected. Texas's focus on the precise nature of Johnson's expression, moreover, misses the point of our prior decisions. Their enduring lesson, that the government may not prohibit expression simply because it disagrees with its message, is not dependent on the particular mode in which one chooses to express an idea. If we were to hold that a state may forbid flag burning wherever it is likely to endanger the flag's symbolic role, but allow it wherever burning a flag promotes that role, as where, for example, a person ceremoniously burns a dirty flag, we would be saying that when it comes to impairing the flag's physical integrity, the flag itself may be used as a symbol, as a substitute for the written or spoken word, or a shortcut from mind to mind, only in one direction. We would be permitting a state to prescribe what shall be orthodox by saying that one may burn the flag to convey one's attitude toward it and its reference only if one does not endanger the flag's representation of nationhood and national unity. We never before have held that the government may ensure that a symbol be used to express only one view of that symbol or its reference. Indeed, in Schacht v. United States, we invalidated a federal statute permitting an actor portraying a member of one of our armed forces to wear the uniform of that armed force if the portrayal does not tend to discredit that armed force. This proviso, we held, which leaves Americans free to praise the war in Vietnam but can send persons like Schacht to prison for opposing it, cannot survive in a country which has the First Amendment. We perceive no basis on which to hold that the principle underlying our decision in Schacht does not apply to this case. To conclude that the government may permit designated symbols to be used to communicate only a limited set of messages would be to enter a territory having no discernible or defensible boundaries. Could the government, on this theory, prohibit the burning of state flags, of copies of the presidential seal, of the Constitution? In evaluating these choices under the First Amendment, how would we decide which symbols were sufficiently special to warrant this unique status? To do so, we would be forced to consult our own political preferences and impose them on the citizenry, in the very way the First Amendment forbids us to do so. There is, moreover, no indication, either in the text of the Constitution or in our cases interpreting it, that a separate judicial category exists for the American flag alone. Indeed, we would not be surprised to learn that the persons who framed our Constitution and wrote the amendment that we now construe were not known for their reverence for the Union Jack. The First Amendment does not guarantee that other concepts virtually sacred to our nation as a whole, such as the principle that discrimination on the basis of race is odious and destructive, will go unquestioned in the marketplace of ideas. We decline, therefore, to create for the flag an exception to the joust of principles protected by the First Amendment. It is not the state's ends, but its means to which we object. It cannot be gainsaid that there is a special place reserved for the flag in this nation, and thus we do not doubt that the government has a legitimate interest in making efforts to preserve the national flag as an unalloyed symbol of our country. We reject the suggestion, urged at oral argument by counsel for Johnson, that the government lacks any state interest whatsoever in regulating the manner in which the flag may be displayed. Congress has, for example, enacted precatory regulations describing the proper treatment of the flag, and we cast no doubt on the legitimacy of its interest in making such recommendations. To say that the government has an interest in encouraging proper treatment of the flag, however, is not to say that it may criminally punish a person for burning a flag as a means of political protest. National unity as an end which officials may foster by persuasion and example, is not in question. The problem is whether, under our Constitution, compulsion, as here employed, is a permissible means for its achievement. We are fortified in today's conclusion by our conviction that forbidding criminal punishment for conduct such as Johnson's will not endanger the special role played by our flag or the feelings it inspires. To paraphrase Justice Holmes, we submit that nobody can suppose that this one gesture of an unknown man will change our nation's attitude towards its flag. Indeed, Texas's argument that the burning of an American flag is an act having a high likelihood to cause a breach of the peace, and its statute's implicit assumption that physical mistreatment of the flag will lead to serious offense, tend to confirm that the flag's special role is not in danger. If it were, no one would riot or take offense because a flag had been burned. We are tempted to say, in fact, that the flag's deservedly cherished place in our community will be strengthened, not weakened, by our holding today. Our decision is a reaffirmation of the principles of freedom and inclusiveness that the flag best reflects, and of the conviction that our toleration of criticism, such as Johnson's, is a sign and source of our strength. Indeed, one of the proudest images of our flag, the one immortalized in our own national anthem, is of the bombardment it survived at Fort McHenry. It is the nation's resilience, not its rigidity, that Texas sees reflected in the flag. And it is this resilience that we reassert today. The way to preserve the flag's special role is not to punish those who feel differently about these matters. It is to persuade them that they are wrong. To courageous, self-reliant men, with confidence in the power of free and fearless reasoning applied through the processes of popular government, no danger flowing from speech can be deemed clear and present unless the incidence of the evil apprehended is so imminent that it may befall before there is opportunity for full discussion. If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence. And precisely because it is our flag that is involved, one's response to the flag burner may exploit the uniquely persuasive power of the flag itself. We can imagine no more appropriate response to burning a flag than waving one's own, no better way to counter a flag burner's message than by saluting the flag that burns, no surer means of preserving the dignity even of the flag that burned than by, as one witness here did, according its remains a respectful burial. We do not consecrate the flag by punishing its desecration, for in doing so, we dilute the freedom that this cherished emblem represents. Section 5. Johnson was convicted for engaging in expressive conduct. The state's interest in preventing breaches of the peace does not support his conviction, because Johnson's conduct did not threaten to disturb the peace. Nor does the state's interest in preserving the flag as a symbol of nationhood and national unity justify his criminal conviction for engaging in political expression. The judgment of the Texas Court of Criminal Appeals is therefore affirmed.